Hi everyone, Lee Pacchia here, and I'm joined now by Professor Appel. He, of course, is a professor of law at New York Law School, and he's also the director of the International Tax Program at the school. Welcome back. Good to see you.
Hi, Lee. Thanks for having me back.
Of course. I didn't expect it to be quite so soon. Last time you were on the program, we're talking about the foreign account disclosure program that the IRS is going through. And I think like 10 hours after we had you in the studio, they finally came out with the changes that we anticipated on that previous program. So we have the rules in front of us, or at least the proposed rules.
Yeah.
What do they say?
Well, they're not proposed because this is a policy. It's not a matter of taxpayer right.
Mm-hmm.
If the taxpayer wants to take advantage of the program, the taxpayer is free to participate, but it's not something that can be negotiated. The program itself was significantly changed or amended, some for the better and some for the worse.
Mm-hmm. All right, well, let's start with the good news,
Okay,
I guess,
the
first.
good news is that if you are a U.S. citizen or resident who is residing outside of the United States, and what that means is that you're living outside of the United States for 330 days in any 12-month period.
Okay.
You consider to be a non-resident. And what they've done is they have a new criteria for what was called and still called the Streamline Program. A U.S. citizen that is residing outside the United States and is not willful, and we'll talk about the meaning of that in a few minutes.
Yeah, that's where I want to go next.
Yeah, and not willful, and has paid their foreign taxes and filed the foreign returns, but neglected to file their U.S. income tax returns or the foreign bank account reports, can come in and get right with the system by filing 3 years of tax returns,
Mm-hmm.
paying any taxes that are due on the return, and also filing 6 years of the foreign bank account report, the FBAR forms, sent into the government, and there'll be no penalties. If you're a U.S. resident and you are living in the U.S. and you are not willful, you can also participate in this program and be subject to a 5% penalty.
5% of what?
5% of the undeclared amount in the foreign accounts.
Okay. So now the bad.
Okay, the bad news is that if you are not eligible for the Streamline Program and you want to participate in the overall offshore voluntary disclosure program, it became a little more difficult and the penalties are higher. So under the new program, the bad news is that, number one, it's harder to get pre-cleared. Number two, you now have to submit with your voluntary disclosure 8 years of tax returns.
A fair amount of paperwork.
Yeah, immediately, along with your request, and all of the taxes, the interest, and the penalty, which is 27.5% of the highest balance in the foreign account over the last 8 years. It gets worse, though, because if you do this, make this disclosure after August 4th, and you had money in one of a list of 10 banks that the IRS has published, UBS, NT Butterfield, HSCB, all of these banks, and there's several others. If you're on the list, the penalty goes up from 27.5% to 50%.
Wow.
Of the highest balance in the offshore account. So it's gotten harder for the people to want to come in and enter the program. They have to do a lot more, but it's gotten easier for the people that didn't know that they had to file U.S. returns on the foreign income.
So let's turn to the issue of willfulness.
Yeah.
It sounds awfully important here. How does the IRS define and determine something like that?
Very similar to the Supreme Court opinion on pornography.
Mm-hmm.
You'll know it when you see it.
Right.
But seriously, the IRS said, we're going to leave the definition of willfulness to the tax practitioner. Mm-hmm. And the taxpayer should get advice from tax counsel to see whether or not they were willful or not. It's good for business, for tax lawyers. Mm-hmm. And my advice certainly would be to anyone who wants to participate in the Streamline Program and thinks that they're not willful, they must seek counsel from a tax lawyer, not a tax accountant, but a tax lawyer, and not just any tax lawyer, but they would be well advised to speak to a criminal tax lawyer.
Huh.
Because willfulness is potentially a criminal issue, and you can inadvertently become willful. For example, if you had money put in a Swiss account to take advantage of bank secrecy. That's one evidence of willfulness. If there's $10 million in a foreign account, that's probably prima facie willfulness. People may think that things are not willful because they were told by a relative never to tell anybody about it, or they were movement of, let's say, a person has an account at UBS. Now UBS is under investigation, so they move it to another bank. That's evidence of willfulness. It's very hard to determine. I think what might not be willfulness would be if there was an inherited account that you didn't know about, there were no withdrawals taken out of it, things like that. But it's a slippery slope, and it's really a trap for the unwary, and you have to be very careful of that when dealing with willfulness.
No, this is complicated stuff. I have to ask: does this rule punish people who previously disclosed their accounts before the new version came out?
The answer is that the people that disclosed would qualify for this, that disclosed accounts before the new version came out, were subject to a 5% penalty. And there weren't that many of them, because in order to qualify for the old streamlined program, you had to have less than $1,500 in U.S. source income. So it's very few people really qualified. I don't know the statistics, and I don't think there are that many statistics on how many people came in under the streamlined program. But the fact that they came out with another program is a good indication that not too many people qualified or were able to take advantage of it.
It's been reported in a number of places that a large number of American citizens living abroad are renouncing their citizenship in order to get away from this policy that the IRS is currently carrying out. Do you think that trend had anything to do with this new rule coming out?
I don't think it was the new rule coming out. When I was practicing at the law firm of Brian Cave years ago, prior to becoming a professor of law, we had and they still do have, a very vibrant practice in expatriating U.S. citizens. But it wasn't because of this program or this new rule. It was because these people didn't want to pay U.S. taxes or be subject to the U.S. filing requirements. On the other hand, there's such great benefit to being a U.S. citizen that taxes shouldn't be driving this. And in transactions, we counsel clients not to let the taxes motivate the transaction, but let the business motivations be primary. And I think it's the same thing with expatriation. Clients should be thinking long and hard about giving up citizenship and shouldn't do it primarily for taxes.
Big decisions and complicated stuff.
Yeah.
Alan, thanks for coming
My
in
pleasure.
and explaining this. That's Professor Alan Appel from New York Law School. If you'd like to see more of the things that the law school is working on, be sure to go check them out on YouTube, and you can always follow them on Twitter. I'm Lee Pacchia. Thanks for watching.